All right, and so right now, joining us live in the studio is our legal analyst, Sean Toomey. Thank you, Sean, as always, for your time. We talked about the political ramifications. Let's talk about the legal aspect first. Procedurally, what are some of the next steps to take place before the possible trial date of November 17th?
Sure. So now that she's been arraigned, there'll be an exchange of discovery. There'll be some motion practice, and ultimately there's going to be a trial. It's not going to happen in November. Mr. Officer Vappy's trial, I think, is set for February 20th. That's probably unrealistic as well. I would suggest most likely the summer of 26.
Then why such a speedy date of November 17th?
Well, there's a statutory requirement. It's called the Speedy Trial Act that requires the magistrate judge to set the trial date within 70 days of their initial appearance, which was today.
And if she is convicted, we're facing some serious charges here, 11 felony counts. What are the penalties and restitution she faces?
So each count has a different max penalty. Some are as high as 20 years, others are as low as 5 years. Regardless of which count she's convicted of, her sentence is going to be driven by what's called the guideline range. So it's not an automatic 20 years, it's not an automatic 0. It's driven by the guideline range. And that's typically impacted by the amount of loss, her role in the offense, her position in the city. So that's how this is going to play out.
If you are her defense attorney right now, what's going through your head? What's the strategy being worked on right now to prepare for trial?
You know, it's interesting. In my experience, the government probably has already spoken to her counsel and attempted to try to resolve this before indicting her. That hasn't happened. And so now they're in a different phase. They have to prepare for trial, review the evidence, and potentially continue to negotiate some sort of a plea agreement.
So we may possibly see some sort of plea bargain. We don't know. We'll have to wait and see.
We'll have to wait and see.
Real quickly, one last question before I let you go. Is it usual or unusual to see, the travel restrictions and also kind of, restricting her from talking to other people and witnesses except for city employees?
Yeah, that's par for the course. I mean, she will be able to leave the Eastern District or Louisiana with permission from U.S. probation for any appropriate reason. So she can still travel. She just have to make them aware of it. As far as speaking to witnesses, that can get difficult.
How do you enforce that?
Well, it's difficult because from her perspective, she may not know who the government's witnesses are because the government's not going to tell you who all their witnesses are until essentially the eve of trial, which makes preparing for trial very difficult. So she's really in a tough spot, but for sure, she can't talk to anyone about the facts of the case.
Got it. All right, legal analyst Sean Toomey, thank you always for your insight and for your time.